G'day there guys, Markee here, back at it again with another episode of r/JustnoHOA. Now if you hate the Homeowners Association as much as I and Reddit do, sit back, relax and enjoy the quality content. Posted by user, My HOA Sucks Throwaway, titled, HOA Messed Up Big Time ADA. Okay, so where to begin? I've been in a battle with my HOA for months. This whole mess started when I suspected a board member of receiving kickbacks on jobs, and I and a few homeowners set up a sting operation. A family friend is a licensed contractor and put in a bid for work. The president invited him over, and during the conversation, the president bluntly said any job approval requires a 10% overbid deposit if you want the work. He did record on his phone, but because we're in a two-party consent state, it couldn't be used. We have sent numerous requests for financial records and have been stonewalled for months. The owner of the property management company is in on the scam as well. I and 5 other concerned homeowners have been stonewalled time and time again. We finally banded together, got a lawyer, and of course COVID hits and the courts are closed. So 3 weeks ago, I had a major operation affecting my ability to walk. I am wheelchair bound temporarily. I submitted a request for an accommodation of a ramp I would pay for. These are individual houses and would have zero encumbered on any other homeowner in the community. HOA of course denies the request. Reason? Homeowner has not proven they are disabled. A note from the surgeon was sent over. Denied? Reason? HOA called doctor's office. Doctor does not exist. Homeowner is making false claims. You can't make this crap up, right? So I say screw it and put the ramp up. Board member decides to put brick pavers in front of the ramp with caution tape on it, and a note saying unapproved. Lawyer reached out to board one last time before filing and accidentally got a reply meant for the other board members. I'm going to fudge and get him. He's lying and just trying to be a pain in our ass. Let's just keep denying the requests. We're the motherfudging board. We set the rules and what we say goes. Judge grants injunction and is trespassed from my property. I sort of forget about the whole thing. Board has been leaving me alone until today when 2 board members came banging on my door, telling me they're going to kill me. Thanks, Ring, for recording it all, yelling how they will make me permanently crippled. So, turns out the community's insurance company refused to pay the legal bills. They were also not indemnified because it was done with malice. The 2 board members are on the hook for almost $9,000 in legal fees, plus $35,000 in punitive damages. Apologies for formatting and the rant. I'm still a bit loopy from the meds. Screw these sorry losers, no-life nosy motherfrickers. Make sure to file for an order of protection/restraining order against those 2, and probably the rest of the board as well. Get those recordings to your lawyer ASAP, and sue for the threats. Finally, some good news in the world. Also, threats like that are highly illegal. You could likely call the police and also press charges. Yes, this was a terroristic threat, which is a felony. He can't press charges. The prosecutor has to. But get that police report, then hound the DA. And if they don't do anything, make sure to get your elected officials involved. I'm sure they'd be upset to hear that a disabled person, albeit temporary, was harassed, and the legal system ignored it. You can use that recording. There is no presumption of privacy in a public area. They were in a public area. I would have your attorney present that to the judge. I would also slap liens on their properties to compel them to pay. If they don't, your attorney can get a writ for possession and you can sell their homes. Yes, I fight fudging street dirty. You can also publish all of their crap and send copies to each and every homeowner. Also, speaking in front of a video doorbell like that should be considered giving consent, as they can already clearly see they are being recorded. Wow, this thread went nuclear. That depends on where the conversation with the HOA president occurred. A private conversation between 2 people is not considered an open meeting. The property where the meeting took place is owned by the HOA. In many states, this recording would be criminal without both parties present. A conversation, which did not consist of ticked HOA members pounding at OP's door, shouting death threats. Honestly, do you guys not read to the end of the post before commenting? Wouldn't a functioning Ring doorbell be an odd thing for a contractor to use to record a conversation when he could just use his phone? By the way, your contractor's friend's testimony about the 10% overbid demand is evidence you don't need a recording. The judge will order them to turn over the records whether they like it or not. Audio recorded in a two-party state in a private conversation is unadmissible in court, and in my state, the act of doing it is a felony. But they could be called in to testify. Pretty sure that's what I said. I think he was confused by the turn over the records part. You're referring to the bookkeeping and not the audio recordings. You're right, I could have made that more clear. It is not as simple as that. The contractor can testify that the board member asked for a 10% bribe, and the board member can deny it, at which time the recording may be able to come in as evidence of perjury by the board member. After proving perjury by the board member's testimony would be stricken from the record, and the contractor's testimony about the bribe would be unopposed. Technically, the court would be deciding solely on the contractor's testimony, but the court would have heard the recording in deciding that the board member was lying. The only way to keep the recording out would be if the contractor testifies about the bribe and the board member refuses to testify. A clever attorney will find a way to use any really juicy evidence at his disposal, even if it just gets sent anonymously to the fraud division of the insurance company for the HOA that has to pay the legal bills. Or people have an easier time fighting 3 individual board members all looking out for themselves when the insurance company won't back them. Posted by user Parking Spot Help 1192, titled, Condo board is telling me as of June 5th, the parking spot I own will be converted into a handicapped spot, but there are no other parking spots available. Is this legal? This started back in December. I own a parking spot that is right next to the 3 existing handicapped spots in my condo building. I have paperwork that says I am the owner of the parking spot A5. Me and my wife inherited this condo from my mother. In December, apparently a new tenant moved in who requires a handicapped parking spot. However, our building already does not have enough parking for everyone. For roughly a 100 units, we have maybe 50 spots tops. Back then, I was asked by the condo board if I was willing to give up my spot for these people who need a handicapped spot. I was okay with it until they explained there were no other available spots. Instead, they wanted me to sign over my parking spot in exchange for nothing. Apparently, in 2022, when the parking garage expansion will take place, I will be first on that list to receive one of the new spots. Until then, apparently I'm shit out of luck, since this is downtown Toronto, where parking is extremely limited. At that point, both me and my wife refused to sign anything. In February, the condo board tried to get me to sign paperwork again, and I refused. They offered to pay for a spot for me roughly 10 blocks away at another building. I told the condo board yet again I am not interested. They have tried to guilt both me and my wife numerous times about this. The tenant who needs this spot has approached me and my wife several times about how we are making her life a living hell. In April, the condo board, during the board meeting thing, put a vote asking for people to vote for the conversion of parking spots A5, 6, and A7 to be converted into 2 handicapped parking spots. The motion passed. However, neither me or the people in A6 or 7 are budging so far. Today, I received a letter stating that as of June 5th, 2020, I will no longer be the owner of parking spot A5. I didn't sign any paperwork and have told our condo board to pee off. My questions are, is this legal? Can the condo board take over our parking spot that we own? Do we have any sort of legal alternatives? Just to clarify, I am not really trying to be a dick. However, these new people who moved in bought the unit fully knowing they were not buying a parking spot. Instead, from my understanding is, they expect the apartment building to provide them a handicapped spot free of charge. Location, Toronto, Ontario. This will likely be worth contacting a lawyer about. This is likely illegal, but will depend on what is in your homeownership documents. How is the parking spot defined and what exactly is included? And the condo bylaws. What are their powers, and was proper procedure followed? If there are 2 other people affected by this decision, you might be able to get the same lawyer to represent you. Definitely worth fighting because it can affect the value of your own place. Parking spots are a premium downtown. If you have ownership papers and they bent over backwards to ask so many times, it's likely that they can't do this. Get a lawyer, talk to the folks in the other units, and see if they will go to the lawyer with you. The lawyer will likely be able to write a letter that officially tells them to go pound sand and that they can vote whatever they like, but they can't steal your property. If you own a parking spot, it is likely a registered piece of land in Ontario defined on a condominium plan. If this is the case, the action by your condo board is definitely illegal. I would contact a lawyer immediately and squash this. You are also undoubtedly paying property taxes on the parking stall. I hope you prevail, but if you don't, advise the city tax office that you had to surrender it, so it's not part of your yearly taxes. You have to look at your papers. My condo unit is tied to my parking spot in the bylaw, so they cannot be split apart. Toronto. Gotta see a lawyer to review the specifics of your condo, parking ownership, and if they can be severed or something along that time. Review your bylaws. City of Toronto bylaws also require 1 handicap space per 25 spots. If it's a newer condo building, they should already be in compliance, as well as being accessible. It's the new tenant/owner problem. They should have researched the parking availability prior purchase. Some people feel so privileged that they can just take privileges from other non-disabled people just like that, giving other legitimate handicap a bad rep. Don't sign anything, get a lawyer. Oh, and start documenting timelines, communication with board members, and harassment by the new peeps. Also useful to have a 360 degrees hunting camera in your car if there is no CCTV in the garage, in case they try to convince you via taking care of your car. Posted by user DJ Diabetes 26. Yo, turn the insulin up, boys. County Code Enforcement said we have too many non-related people living in the house. So, for some background, we are 6 college students, all guys, renting a house in a neighborhood with an HOA in Orlando, Florida. We rent from a management company. The house is a 6x4, so everyone has their own room. When we signed our lease, all 6 names went on the lease. In our lease agreement, there was a section stating that if there was an HOA over our rental, the management company would send a copy of the lease to the HOA. We have been living in the house for 3 months now. No issues, other than forgetting to cut our grass. Has since been resolved. Today, a lady came from the County Code Enforcement and asked if we had more than 4 unrelated residents in the house. We said yes, and she told us it was against county ordinance to do so. She said to contact our management company for the next steps to take and gave us her business card. She did not hand us a copy of the ordinance we were violating, and gave us very little in terms of what would happen or how to resolve the issue, other than contact your management company. After finding our HOA's CC and Rs, there's a section that says rentals may only be used for single-family home purposes. So that makes it sound like we are in violation of the HOA, but we could not find anything regarding the county ordinance after spending several hours searching through the county ordinances. So we're trying to figure out our options. Did the management company screw us? They let us sign the lease, knowing there were 6 of us, and knowing we were not related. Is it their responsibility for their tenants not to be in violation of things like that? They said we were fine. Depending on the ordinance, it may be the landlord getting fined for this, not you. If so, the landlord will be highly motivated to work something out to avoid dollar amount per day fines. Not a lawyer, or from Florida, but searching the Orlando Code found they define family is 1 or more persons occupying a single dwelling, living as a single housekeeping unit, provided that unless all members are related by blood, marriage, adoption, or foster care responsibility, no family shall contain over 5 persons. If the home is zoned for a 1-family home, then you may be in violation. Usually, the fines for building code violations go against the property owner, not the residents. But if they come down on your landlord one way or the other, you will probably need to move. And there may well be some generous provisions in the lease to protect the landlord from this sort of thing. Good find. For some reason, I didn't think of checking this for city ordinances, since OP said it was county enforcement. I only looked there. Dole. What piques the law nerd part of my brain is the single housekeeping unit bit. Single housekeeping unit. A group of persons jointly occupying a single dwelling unit that 1. Meet the definition of a family, 2. Has access to and the joint use of all common areas of the dwelling unit, 3. Shares household activities and responsibilities such as meals, chores, or expenses, 4. Has no limit on length of residence except those imposed by a lease or rental agreement, and 5. Rents no more than 4 individual rooms for a period of at least 30 days for compensation under separate leases or rental agreements, until additional leases are required be a government funding program or a shared housing program operated by a federally recognized tax-exempt entity. This, combined with the section you quote, sounds like it makes practically all roommate situations illegal in the city of Fort Orlando. What's more interesting, though, is that the last line, rents no more than 4 individual rooms, so that right there makes it sound like the property owner is absolutely screwed. It doesn't sound like they are renting individual rooms under separate leases. They are renting the whole house together as roommates. This actually sounds like they are fine. Renting individual rooms is like a boarding house, and that seems to be what the wording is directed at. Not a lawyer, but Orlando has very oblique city limits. The main UCF campus and its surroundings are not within the city's jurisdiction. Our people want to check the official jurisdiction map if they are actually within the city. County laws and HOA laws will be different. Most counties in the US have laws about tenants, which your house effectively is. They limit unrelated people from living together. Your landlord, not you, will be looking at serious legal trouble. Some of you will probably have to find a different place to stay, but you have leverage over your landlord because, regardless of county law, she signed a lease stating that you would have a place to live and she has a responsibility to ensure that you do. This can't be the house you're in, though. She will have to buy you out of some of your leases until she meets county code enforcement. Posted by user by Fashion, titled, Isn't HOA obligate to provide assessment bills for its payments? Question. It seems basic and everyone takes it for granted that the association mail the assessment bills, and if you didn't get it for any reason, you could just ask for a replacement copy. But after asking for copies of my undelivered bills since March 2019, and yet to receive all of them, and consider that they would not even provide the current bills during all 2019 while I'm requesting them repeatedly, because I couldn't pay it without the attached coupon. Instead of providing the copies, they gave me a ledger of the account, very confusing to understand, and demand payment according to that. After insisting to receive the bills, they decided to start a collection process, and still refused to give me copies of bills generated for 2 special assessment payment plans. So, I would be able to know the total sum and track the installment still due. Why they refuse to provide it, I don't know, but isn't there any obligation to give a consumer his bill if requested, at least before starting a debt collection procedure and threat to file a lien? Is it such an exaggerated request to receive my bills like everyone else? Not mentioning the interest and legal fees added when the entire country is facing a financial crisis due to COVID-19. I guess they must justify the wonderful reputation that associations and HOA built themselves over the years. HOAs operate under their own set of rules. It's not uncommon for them to engage in things that would otherwise appear illegal. Question for you. What kind of assessment are you referring to? There's monthly dues, which you are required to pay with or without ever receiving a bill, and penalties for violations. Are you referring to something else? Also, you indicated that they've threatened to assert a lien, which seems to mean that you're getting something from them. What do their letters state? It seems odd to me that you're at this stage but claiming total ignorance. Am I missing something? The problem is that this owner just doesn't understand how coupon books work. A coupon book replaces regular statements, and apparently this owner doesn't like that. It's not correct. I did not get a coupon book, nor the bill with the attached coupon. I would be happy to receive any of them, and I tried to get from the start of 2019 to the end of it. I was able to get part of the bills at the end of 2019, and current bills were only sent from the beginning of 2020. I was not able to pay in the bank any bill, because the bank refuses to take a payment from me if I don't have a current coupon. I'm sorry, but you're in the wrong then. The monthly dues are set. They are under no obligation to send you a bill. You are under an obligation to pay your dues every month without them having to babysit you. I hate to ever stand up for an HOA, but this one is on you. It is not a monthly due. It's a special assessment for a material alternation they had no authority to take without a majority vote. But put it aside, those two special assessments has each a deferent total balance and deferent several installment plans that should end at some point. I believe I should be able to have the privilege to know the balance of each one and how many installments remain. And regarding the regular assessment, I didn't ask for a babysitter. I asked for the coupon because without it, the bank would not accept my payment. Moreover, I needed a copy of a current bill to prove my expenses somewhere else. But the main issue is that I needed a copy to proceed a payment at the bank. It was not my demand, it is the bank's demand, and the association is aware of the problem that I couldn't pay without a physical copy. P.S. Yes, I got all of their mail-excluded bills or coupons, and I did notify them that as well, but they never respond that it was impossible to deliver me copies. They said they will attempt to get it and will send it to me, but they didn't provide it. And without saying anything, they started a collection procedure. So I asked the collection agency to provide the bills, but they failed as well. And then suddenly, they started to send bills in 2020. And after I paid every bill I got, for the next bill, they instruct the bank to deny my payments without letting me know. But it sounds like you know how much the special assessment is, yes? They've obviously made a demand for a specific amount. And how much are we talking about? If it's $10,000, then I get what you're complaining about. But if it's a few hundred, then that's a different story. Also, the issue with your bank is you're just making excuses. You can write a check. Or if you don't have checks, then you can get a money order. Come on, you seriously expect people to believe that you can't pay a bill because your bank won't let you? I'm a lawyer, and this is the very first time in my 20-year career that I've ever heard someone claim that their bank won't let them pay a bill. You are very wrong. I don't know why you assume I am playing a smartass. I am not. It was not my bank that refuses to accept a payment without a coupon. It was the association's bank that denied a payment without a coupon. I was not denied because of a check or a money order. It was not the issue. I was denied for having a current coupon. I brought a copy of an old bill I had, and they refused to process payment according to an old bill. The assessment's amounts, I don't know the exact amount and how many installments are due, but the amounts are high, above $10,000 you suggested. It is one special assessment of above $10,000 and a second special assessment that is about $30,000, and a regular assessment that is a $5,000 quarterly. Assume for 5 minutes that I'm not making an excuse and read it again. I promise you I really tried to make a payment, and I really wanted a copy of my bills, to follow up. And because the coupons are mandatory, not by me, if you don't believe me it's okay. You may answer as if my question was theoretically or hypothetically true. Posted by user Useful Idiots. Titled, HOA can't afford to do its job. I'm the president of my neighborhood's HOA, and I can't figure out how to resolve the pickle we're in. It's a very small neighborhood, and just 16 houses. Our dues are $350 a year, and we have no amenities other than common ground at the front of the neighborhood. We have a fence that runs the length of the neighborhood as a barrier to the road, and it falls under the HOA to maintain it. Here's the thing. We can't afford to maintain it. It's literally falling down in places, and we are spending nearly our entire yearly budget doing patch repair jobs. At this pace, it will take us 7 years to fully fix the fence, and by then we'll likely have to start over again. Because we are treading water, everything else looks terrible. We can't afford to water the grass or do weed control. The neighbors with the fence in their yards are complaining about the fence, and the neighbors without the fence are complaining they have to pay $350 and getting literally nothing in return. We have other repairs that are needed, but can't afford them. I figure my options are drastically increasing dues, double or more, or looking for alternative options. I'd like to vote the fence out of the HOA, but I need a majority vote, and none of those 8 houses are going to vote yes, because the fence would then be their responsibility to maintain. Would love help. You honestly can't worry about the neighbors complaining that they are paying $350 and supposedly getting nothing in return. They are. They are getting the fence maintained, which reflects on their property values. That's literally the whole point of an HOA. Either raise the assessment so you can properly fix the fence, or do a special assessments so you can fix it or tear it down? Do you not have any money in the reserves? No. We just took the HOA from the builder about 6 years ago, and I've been dealing with the fence since basically day one. I've never had a chance to save anything. The fence is hardly being maintained. I'm doing as much as I can, but I'm only repairing about $3,000 a year, and the entire fence needs work. It's about $18,000 to fix the entire thing. It's been out of developer control for only 6 years? Was the HOA properly funded when it was turned over? Sometimes, developers purposefully underestimate how much money will be needed to run the association to keep dues artificially low, and make the homes more attractive to buyers. 6 years is awfully soon to be this underfunded. Additionally, only 6 years out from developer control seems very soon for a fence and wall to be failing. Is there a possible construction defect? You may want to talk to the HOA attorney. If it's the same one the developer hired, you may want to shop around for a new one. Bring up the possibility the developer purposefully underfunded the association. You may be able to pursue the developer. You may want to do this sooner rather than later, since each state has a different statute of limitations. It's a perfect storm of bullcrap. Yes, only 6 years out from the developer. We inherited the HOA with literally $0, and both water and electricity turned off from non-payment. I went after the builder, or builders, who each pointed to the other. There were two, because the OGs sold off half the neighborhood during the housing crash. The fence is failing because it was built in 2007, when the neighborhood construction began. Because of the crash, it was a construction site with 0 houses for 5 years, until my family bought the first house in 12. The neighborhood was finished a couple years later, and they handed the HOA to us in shambles. I didn't think I could go to the HOA attorney, but I don't know that I have any real complaints. You won't know until you consult them, and if you keep letting the clock run, you may lose any claims you did have while you get deeper and deeper underwater. Don't know what state you're in, but in some states, these types of claims, the loser pays attorney fees, so some firms will agree to defer their fees until they win or the case is settled. If you can't afford to maintain the HOA properties, then you have to raise the assessments. You should also have money in the reserves. I know people don't like to raise assessments, but they really should be going up regularly. I've raised the dues yearly, and the fence is just getting worse. We have nothing in reserve because the fence needs to be completely replaced, and it's getting worse yearly. I suppose I get to be the bad guy at the next meeting. Then you will need to do a special assessment. Don't worry, you get used to being the bad guy. Thanks for the advice. Is there a resource where I can read more? What kind of notice should we provide on a special assessment? I figure I can't just drop a $1,000 bill on everyone. Is there not an option to just remove the fence? You could probably remove the fence depending on how things are in your state, and what your bylaws say about what needs a vote and not. Usually, those kinds of decisions are up to the board though. Every state is different with how they deal with these things. That is why HOAs tend to hire management companies, because they are trained to know what the laws are in your state. Yeah, we can change the HOA covenants with a majority vote, which I know won't happen under normal circumstances, but I figure is more likely once the half of the neighborhood without the fence realizes they have to pay $1,000 to fix someone else's fence. So yeah, it seems like the answer to this one is special assessment, as much as everyone hates to have to pay for someone else's problem. I'm gonna leave this one there. G'day there guys, Outro Markee here. Hope you enjoyed the episode as much as I enjoyed making it today. If you did, be sure to like, comment and subscribe. Tell me what you thought about it down below. Also, if you like memes, be sure to head on over to my second channel, Markee 2. It should be one of the sexy Australian faces on screen, the one without the flag. It's my latest and greatest creation, and I hope you like it. Also, I'd like to give a huge shout out to my channel members and Patreon subscribers. You guys do so much good for me, and the support goes without saying, but I'm gonna say it anyway. I love you guys, and I appreciate all the help and support you provide me on this channel. Also, if you want to join the family, links are down in the description below, or click that join button next to the subscribe button. Anyway guys, I hope you enjoyed that one today. I'll see you in the next one. Bye!